If you are a naturalized U.S. citizen, there is an important development you should understand. Not to panic, but to stay informed. In June 2026, the Department of Justice, DOJ, working with U.S. Citizenship and Immigration Services, USCIS, announced that it had filed civil denaturalization complaints against 17 naturalized citizens in federal courts across multiple states. These cases involve individuals from a range of countries and are based on serious allegations, including concealed criminal conduct, fraud, identity misrepresentation, and related offenses. It is critical to understand what this does and does not mean. First, denaturalization is not automatic. Citizenship cannot simply be taken away by an immigration officer. The government must file a lawsuit in federal court. The individual has the right to legal representation and the right to defend themselves. A federal judge must determine whether the legal standard has been met. Second, the authority to revoke citizenship is not new. Under the Immigration and Nationality Act, naturalization may be revoked if it was illegally procured or obtained through concealment of a material fact or willful misrepresentation. Historically, this authority has existed for decades. What has changed is the scale and prioritization. From 1990 to 2017, the U.S. government averaged roughly 11 denaturalization cases per year nationwide. Since mid-2025, DOJ leadership issued guidance encouraging attorneys to prioritize denaturalization where evidence supports it. Independent reporting indicates a measurable increase in filings in 2026 compared to prior decades. The 17 cases announced in June 2026 follow additional filings earlier in the year. This reflects a broader enforcement initiative rather than an isolated action. Now, here is an important legal detail. There is no statute of limitations for civil denaturalization. That means the government can bring a case years or even decades after naturalization if it alleges that fraud or material misrepresentation occurred during the naturalization process. Many recent cases reportedly involve allegations that applicants failed to disclose serious criminal conduct that occurred before or during the naturalization process. During a naturalization interview, applicants are asked under oath about criminal history, including crimes for which they were not arrested. If the government later proves that an applicant knowingly concealed material information, that concealment may form the basis for denaturalization. It is equally important to note that denaturalization requires the government to meet a high evidentiary standard. The U.S. Supreme Court has held that citizenship cannot be revoked unless the government proves its case with clear, unequivocal, and convincing evidence. This is a higher standard than typical civil litigation, though lower than criminal beyond a reasonable doubt. Denaturalization is a formal court proceeding. It takes time, resources, and substantial proof. It is not an administrative shortcut. So what does this mean for naturalized citizens? If you obtained your citizenship honestly and fully disclosed your history, there is no reason to panic. The overwhelming majority of naturalized citizens will never face denaturalization proceedings. However, if you have concerns about past non-disclosure, such as prior criminal incidents, identity inconsistencies, or immigration violations that were not fully disclosed, it may be wise to consult a qualified immigration attorney for a confidential review of your case history. For those currently applying for naturalization, the key takeaway is straightforward. Be completely truthful in all filings and interviews. Disclose arrests, charges, and other relevant matters fully and accurately. If you are unsure whether something must be disclosed, consult counsel before filing. Denaturalization is not a mass program targeting ordinary naturalized citizens. It is a legal tool used in cases where the government alleges serious fraud or concealment. The current increase reflects an enforcement policy decision, not a change in the legal standard itself. As always, this information is provided for general educational purposes only and is not legal advice. Immigration matters are fact-specific. If you have questions about your own situation, consult a licensed immigration attorney who can review your history in detail. Staying informed with accurate information is the best protection against fear and misinformation.